You're building on my driveway. Vanessa Cole actually laughed, not a nervous laugh, not the kind people make when they think there has been a misunderstanding. She looked at the concrete foundation stretching across the gravel access road behind my property, then at the framing crew unloading lumber beside it, and laughed. Ethan, that is not your driveway. I've been driving on it for 26 years. That doesn't make it yours. My deed does. Vanessa folded her arms over the red blazer she wore whenever she wanted everyone to know she was speaking as president of the Briar Glen Homeowners Association. The HOA site map puts the boundary 12 feet west of that gravel. Your site map isn't a boundary survey. It was good enough for the architectural committee. Then your architectural committee approved a garage on land it doesn't own. Her smile disappeared for half a second, then came back. Behind her, the new garage foundation was enormous. 3 bays, a workshop extension, storage loft above, stone veneer stacked on pallets. Vanessa and her husband had demolished their old detached garage 2 months earlier and started replacing it with what she called their carriage house. The problem was where they put it. The southern corner crossed the old gravel lane that ran from my house to a workshop at the rear of my property, and I was almost certain part of the foundation itself crossed my property line. I pointed at the crew. Stop construction until we get a licensed survey. Vanessa shook her head. No. You're willing to risk finishing that building before you know where the boundary is? I know where the boundary is. Based on what? The HOA records. I looked at the foundation, then back at her. Okay. She tilted her head. Okay. I'm ordering a survey. Vanessa smiled again. Waste your money. 3 days later, a licensed surveyor named Owen Price spent nearly 7 hours on the property. He located the recorded monuments, checked the subdivision plat, compared the legal descriptions, ran the line twice. Then he drove 2 bright orange stakes into the ground. One stood inside Vanessa's freshly poured concrete apron. The other stood almost 4 feet inside the framed south wall of her new garage. Vanessa came outside. She stared at the stakes, then at Owen. That's impossible. Owen handed me the preliminary field sketch. It was worse than I expected. The garage itself crossed onto my parcel, but that wasn't all. Its foundation also covered part of a recorded access strip that had served my rear workshop since before Briar Glen existed. I looked at Vanessa. 3 days earlier she had laughed. Now she said, "You can't make me tear down a building over 4 feet." I didn't answer. Because at that point nobody was talking about demolition. Not yet. I gave her a copy of the survey. My attorney sent a written notice. The county issued a stop work order pending boundary review. Her own contractor emailed her recommending that construction pause. Vanessa kept building. Walls, roof, doors, electrical, stone veneer. Every week the garage got more expensive. Every week the paper trail got worse. She apparently believed the same thing right up until the morning a yellow excavator rolled off a lowboy trailer at the end of my driveway. Vanessa came running out of her house. "What is that doing here?" The operator shut down the engine. A county enforcement officer stepped out of the truck behind him. I held the final order in my hand. Vanessa looked at the machine, then at the garage. She wasn't laughing anymore. "My name is Ethan Walker. I was 52 years old. For most of my adult life I had worked in excavation and site development. Not surveying, not real estate law, dirt, drainage, foundations, retaining walls, driveways, utility trenches. For 29 years. If somebody needed to know how water would move across a site or whether a machine could reach the back of a property, that was my world. I sold my share of the company 2 years earlier, semi-retired, which mostly meant I stopped managing 30 employees and started fixing everything I had ignored at home for 20 years. My property was 11 acres on the western edge of Briar Glen. The house had belonged to my parents. Behind it sat an old cinder block workshop my father built in 1987. Dad repaired farm equipment there. I later used it to restore old tractors and store my compact excavator. The workshop mattered to me, but the road leading to it mattered just as much. It was a 12-foot gravel lane running along the eastern side of property. The lane existed before Briar Glen, before Vanessa's house, before the subdivision entrance, before the HOA. Old aerial photographs showed it. Dad's closing documents showed it. County tax maps showed it. I had driven dump trucks down it when I was 23. My father had driven tractors down it before that. Then Briar Glen expanded in the late 90s. The lot beside us became Lot 47. Eventually Vanessa and Richard Cole bought it. For years we had no major problems. There was an old hedge near the boundary. Their lawn on one side, my gravel lane on the other. Then Vanessa became HOA president. That changed the tone. She started treating anything visible from Briar Glen as though the association had some say over it. My trailer, my workshop doors, a stack of drainage pipe, even the color of the shed behind my barn. Every time I gave her the same answer. My property isn't in Briar Glen. Every time she gave me some variation of, but it affects Briar Glen. Nothing came of it. Then Vanessa decided to replace her garage. Her old garage was a 2-car detached structure behind the house. The replacement was much larger. 3 bays, finished loft, workshop, bathroom, heating, stone facade, a wide concrete apron. I first heard about it when a contractor knocked on my door. He asked whether his crew could temporarily stage a skid steer on my gravel lane. I said no. Not because I was trying to be difficult, because I used the lane. The contractor was polite. No problem, I asked. How close are you building to the line? He pointed toward the hedge. Site plan says we've got room. I looked at his stakes. Something felt wrong. One corner stake sat almost in the gravel. I asked, who established the property line? The plan came from the owner. Surveyor? Not sure. I walked over to Vanessa's house. She was outside with the designer. I told her the construction stake looked too far west. She said, the architectural committee already approved it. That doesn't answer my question. What question? Who located the boundary? Our plan shows it. What plan? The HOA site map. That phrase bothered me. An HOA site map can show a lot, lots, roads, common areas, landscaping. It is not automatically a boundary survey, I told her. Before you pour anything, get the line marked by a licensed surveyor. Vanessa sighed. Ethan, you've spent your career moving dirt. We have professionals handling this. I looked at the stake. Then one of your professionals should verify it. She didn't. 2 weeks later, forms went up. Then rebar. Then concrete trucks arrived. I was away for 3 days helping my daughter move into a new apartment. When I came back, the foundation was poured, and the concrete apron cut directly across the gravel lane. I parked my truck, walked down there, and found Vanessa taking pictures of the new foundation. That was when I said, "You're building on my driveway." And Vanessa laughed. I called Owen Price that afternoon. Owen had surveyed commercial sites for more than 20 years. We had worked on several projects together before I retired. I told him exactly what I needed. Not a favor, not an opinion. A boundary survey. Soon? Very. He came 3 days later. I stayed out of his way. That was important. I knew enough about construction to know what I didn't know. I wasn't a licensed surveyor. Owen was. He found the original subdivision monuments. Recovered an older iron pin referenced in my parents' deed. Checked the recorded plat. Compared bearings and distances. Then checked everything again. Around 2 in the afternoon, he called me over. You were right to stop guessing. How bad? He pointed. The actual property line ran east of the old hedge for part of its length. The hedge had never been the legal boundary. Vanessa's HOA map appeared to treat it as though it were. Her garage foundation crossed the line by approximately 3 feet at one corner and just over 4 feet along part of the south wall. The concrete apron extended farther. Then Owen showed me the second issue. My deed contained a specifically described access strip associated with the rear portion of the parcel. The garage and apron interfered with it, Owen said. Get your attorney involved before you do anything. I did. Her name was Rachel Kim. Rachel handled property and construction disputes. She reviewed the survey, then the deed, then Vanessa's building permit. That permit created another problem. The permit set showed a setback measured from a boundary line that did not match Owen's survey. Rachel asked, who prepared this site plan? The title block named an architectural drafting firm, not a survey company. The plan included a note. Property lines per owner supplied information. That sentence mattered. Rachel sent Vanessa and Richard a formal notice. It included the survey. It stated that the structure appeared to encroach on my property and interfere with recorded access. It requested an immediate construction pause while the boundary issue was resolved. She also sent the notice to the contractor. The contractor stopped work the next morning, for about 6 hours. Then Vanessa called me. You contacted my builder? My attorney notified everyone involved. You are interfering with a permitted project. Your permit doesn't give you permission to build on my land. The survey is wrong. Hire another surveyor. We don't need to. Then don't build. She lowered her voice. You have no idea what delays cost. I spent 29 years in construction. I know exactly what delays cost. Then you understand why I'm not stopping over one man's opinion. One licensed surveyor's measurement. She hung up. That afternoon work resumed. I called Rachel. She told me not to confront the crew. Instead, we contacted county building enforcement. An inspector came out. He looked at the permit, then Owen's stakes, then the foundation. The county issued a temporary stop work notice on the portion of construction affected by the boundary discrepancy pending verification. Vanessa hired an attorney. Good, that was exactly what she should have done. Her attorney hired another licensed surveyor, even better. 5 days later, the second survey came back. It differed from Owen's by less than 2 inches. The garage still crossed the line. I thought that would end the argument. Instead, Vanessa changed the argument. Her attorney proposed that I sell her the strip beneath the garage. I declined. Then they proposed a permanent easement. I declined that too. Not because I wanted her garage demolished. Because the strip wasn't useless land. It was my only practical vehicle access to the rear workshop. If I gave it up, I couldn't get my equipment back there without creating a new road across a drainage swale and removing several mature trees. Rachel explained that in writing. Vanessa came to my house the next evening. You're really going to do this over a few feet? You built a wall across my access. You could move your driveway. You could move your garage. Her jaw tightened. Do you know what that would cost? That was why I told you to survey before you poured. You don't need that road. I looked toward the workshop. My excavator is back there right now. Use a smaller vehicle. I actually laughed at that. Not because it was funny. Because I couldn't believe she said it. You want me to change how I use my property because you built on it? You're being unreasonable. No, I'm being very specific. I pointed toward the orange survey stake. Your property is on that side. Then toward mine. Mine is on this side. She stared at me. Concrete doesn't move because you put a stake next to it. She was right about one thing. Concrete doesn't move easily. But that didn't mean it got to stay. The county stop work order should have frozen the project. Instead, construction started happening in pieces. A roofing crew showed up on a Saturday, then electricians, then stone masons. Vanessa argued that some work was outside the disputed area. Some of it probably was. Some clearly wasn't. I documented everything from my property. Dates, vehicles, photographs. No shouting, no blocking trucks. No walking onto Vanessa's lot. Rachel handled the notices. Then the original general contractor called me. His name was Mark Ellis. He sounded uncomfortable. I want to be clear about something. Okay, we recommended stopping. I know. No, I mean before the foundation. That got my attention. Mark said that when his superintendent saw how close the stake line was to the gravel road, he asked Vanessa for a boundary confirmation. She sent him the HOA site map. The superintendent replied that it was not a survey. Mark recommended locating the boundary before concrete. Vanessa responded in writing. Proceed according to approved site plan. Boundary has already been established through HOA records. I said, do you still have that email? Yes. Give it to your attorney. I already did. Mark's company had now withdrawn from the project. Vanessa hired separate subcontractors to continue. That was her second major mistake. The first was building before verifying the boundary. The second was continuing after 2 surveys said the same thing. Then Rachel found something else. The county permit file contained 2 site plan versions. The first was an early concept. It showed the proposed garage closer to Vanessa's house and clear of my gravel access. The second shifted the structure west. Why? The HOA Architectural Committee wanted more separation between the garage and Vanessa's patio pool area. So the garage moved toward my property. The revised drawing used the hedge as a visual reference for the western boundary. But no surveyor had certified that line. Vanessa had submitted the revised plan with the owner-supplied boundary information. That did not automatically mean fraud. It did mean the entire expensive problem originated with a line nobody had professionally verified. And Vanessa had been warned about exactly that. Rachel filed for injunctive relief. Vanessa's attorney argued that demolition would be economically disproportionate. They offered money, then more money, then landscaping, then a newly constructed alternate driveway at Vanessa's expense. I considered the alternate road. I really did. An engineer looked at it. The route crossed a seasonal drainage swale. It would require a culvert, tree removal, grading, additional permitting, and it would create a steeper turn into the workshop yard. Also, Vanessa could keep a garage she had been warned not to finish. I declined. The court issued an interim order prohibiting further work affecting the disputed strip. By then the garage had walls, roof, doors, windows, and much of the exterior stone. Vanessa still believed completion would save it. I knew because she told me. We were both leaving a preliminary hearing when she stopped beside the courthouse steps. You know nobody is going to order a finished building torn down over 4 feet, I said. Then why did your lawyer tell you to stop building? Her expression changed just slightly. That told me enough. She walked away. 2 days later, electrical trim work continued inside the garage. Rachel documented it, the county documented it. Vanessa called it preservation work. The judge did not find that explanation particularly persuasive. The dispute had stopped being about an innocent construction mistake. It was becoming a record of what Vanessa did after she knew. The final hearing happened 6 months after I first saw the foundation. By then, I was tired of the garage, tired of photographs, tired of certified letters, tired of hearing the phrase only 4 feet. 4 feet sounds small until somebody puts a building in it. Owen testified about the survey. Vanessa's own surveyor agreed with the boundary within normal tolerance. The engineer testified about the access route and why moving it was not equivalent to restoring the existing lane. Mark's attorney provided the construction correspondence. The sequence was simple. Contractor questions boundary. Contractor recommends verification. Vanessa says proceed. I object. Independent survey confirms encroachment. My attorney sends notice. Second survey confirms encroachment. County issues stop work direction. Construction continues in stages. Vanessa's attorney argued that the encroachment had not been intentional at the beginning. Rachel did not need to prove that it was. Her argument focused on what happened afterward. Vanessa had multiple opportunities to minimize the damage. Before foundation, after my objection, after Owen's survey, after her own survey, after the county notice, after the interim order. Each time the project became more complete and more expensive. The judge asked Vanessa directly, "Why did construction continue after your own survey confirmed the encroachment?" Vanessa said, "We believed a reasonable accommodation would be reached." The judge asked, "Did Mr. Walker agree to sell or relocate his access?" "No." "Did he agree to an easement?" "No." "Then what accommodation did you believe had been reached?" Vanessa paused. "None yet." That was the problem in one sentence. She had built as though my eventual agreement was guaranteed. It wasn't. The final order required Vanessa and Richard to remove all portions of the garage, foundation and apron encroaching on my parcel and restore the affected access. They were given a deadline. The order also required compliance with county permitting and safety requirements during removal. Vanessa did not lose her entire house. She did not lose her property. Nobody awarded me her garage. Nobody gave me some fantasy $1 million payout. She was ordered to correct the encroachment she had chosen to keep expanding after notice. The engineering problem was that the garage could not simply be sliced 4 feet narrower. The affected wall supported roof loads. The foundation and structural system were integrated. Vanessa obtained 2 contractor evaluations. Both concluded that partial removal and reconstruction would be extensive. Her insurer disputed coverage for portions of the loss. Her contractor dispute continued separately. None of that changed the deadline. Then the HOA became involved. Until then, Vanessa had repeatedly told residents this was a private boundary dispute caused by a hostile neighboring property owner. Thomas Reed, the HOA treasurer, requested the architectural review file. What he found embarrassed the board. The architectural committee had approved the garage based on owner-supplied boundary information. No independent survey had been required despite the structure sitting close to an external parcel. Worse, after Owen's survey came in, Vanessa had sent an email from her HOA president account stating, "The association recognizes the approved site plan and will support completion of the project." The board had never voted on that. The association's attorney had never approved it. Vanessa had used her title to make a private construction dispute sound like an HOA position. At the next board meeting, she was removed from all architectural committee authority pending review. A month later, residents voted her out as president. That wasn't something I requested. By then, I barely cared who ran Briar Glen. I wanted my road back. The removal deadline approached. For weeks, nothing happened. Then Rachel received notice that Vanessa had contracted a demolition and structural removal company. They needed temporary access from my side to remove the encroaching portion safely. The irony was hard to miss. For months, Vanessa had acted like my access road was expendable. Now her contractor needed that same road to bring in the machine that would undo what she had built across it. I signed a limited temporary access agreement, specific dates, specific equipment, restoration requirements, insurance certificate, everything in writing. Mark would have appreciated it. The demolition company scheduled the work for Monday. At 7:15 that morning, I heard a diesel engine on the county road. Then I saw the lowboy trailer and the yellow excavator sitting on it. That was the moment the argument finally became physical reality. People call every large yellow machine a bulldozer. This one technically wasn't. It was a 30-ton excavator with a hydraulic thumb and concrete processor. But the excavator doesn't have quite the same ring to it. The lowboy stopped near my driveway. A support truck pulled in behind it. Then a county vehicle. I had already moved my pickup and compact excavator out of the rear workshop. The contractor superintendent walked the site with me, then with Vanessa's representative. The removal plan had been approved. Utilities serving the garage were disconnected. The work zone was marked. Nobody was improvising. Vanessa came outside just as the excavator was being unloaded. She wore a red coat over dark pants. She looked at the machine, then at me. "What is that doing on your driveway?" I almost reminded her that 6 months earlier she had insisted it wasn't my driveway. "I didn't," I said. "Your contractor requested access." "My contractor?" I pointed toward the superintendent. He walked over. "Mrs. Cole, we're scheduled to begin at 8. She looked stunned. "I thought you were starting with interior salvage. We finished salvage Friday. You're not touching the stone today." He held the work order. "Exterior removal begins today." Vanessa looked at me. "You couldn't wait to see this." That wasn't true. If anything, I had spent 6 months wishing none of it had happened. "I asked you to stop before the walls went up. You wanted this. I wanted my driveway. Same thing." "No." I looked at the garage. "It really isn't." At 8:03, the excavator started. The first work was careful. Stone veneer came off. Sections were separated. Materials that could be salvaged were stacked. Then the machine began breaking concrete. The The sound traveled across Briar Glen. Residents appeared at the ends of driveways. A few stood on the sidewalk. Nobody cheered, at least not where I could hear them. That was better. This wasn't a football game. It was an expensive correction to an avoidable mistake. By noon, part of the garage wall was gone. By the second day, the roof structure over the affected bays had been dismantled. By the fourth, the foundation crossing my parcel was exposed. The concrete processor cracked it into sections. I stood near the old workshop and watched the gravel lane slowly reappear. That was the part that mattered to me. Not Vanessa's face, not the machine, the road. A strip of compacted gravel that had existed quietly for decades. By the end of the week, the encroaching construction was gone. What remained of Vanessa's garage required substantial redesign and reconstruction entirely within her parcel. The demolition company removed debris. A grading crew restored my lane. Fresh gravel went down. Drainage was repaired. Owen returned one last time. He verified the boundary and provided an updated record drawing of the restored condition. This time, nobody laughed at the orange stakes. Vanessa's legal dispute with her contractors and insurer continued. I wasn't involved. The HOA changed its architectural rules. Any major structure proposed within a specified distance of an external property boundary now required is a licensed boundary survey, not an HOA map, not a hedge, not an owner's guess, a survey. Thomas Reed became interim president. One afternoon he walked over while I was grading the lane. He said, "We should have required that years ago." Probably. Would have saved everybody a lot of money? Probably. He looked toward Vanessa's partially reconstructed garage. "You're not much for speeches, are you? I spent 30 years around excavators. What does that have to do with speeches? Machines don't care how long you explain something." He laughed, then went home. A week later, I drove my pickup down the lane to the workshop. First time in months. I didn't realize how much I had missed something that ordinary. Open the gate. Shift into drive. Gravel under the tires. Workshop straight ahead. No construction fence. No concrete apron. No wall. Just access. Exactly where it had always been. Ending. The strangest thing about the whole dispute was how preventable it was. Vanessa did not wake up one morning and decide, "I'm going to build a garage on Ethan Walker's property." At least I don't believe she did. The original mistake was much more ordinary. Someone relied on the wrong line. A hedge, an HOA map, owner-supplied information, a drawing that should have been verified before concrete. Construction mistakes happen. I've made them. Everyone who has spent enough years on job sites has. The difference is what you do when someone points at the mistake. You stop, you measure, you verify, and if you're wrong, you fix it before the roof goes on. Vanessa did the opposite. That was what made the garage expensive. Not my survey, not the judge, not the excavator. Every warning she ignored added another layer. Concrete, framing, roofing, electrical, stone. She kept turning a correctable problem into a larger one because she believed cost would eventually become an argument in her favor. If the garage became expensive enough, surely nobody would make her move it. If it became finished enough, surely my driveway would become negotiable. If she kept going long enough, surely reality would adjust itself around the building. It didn't. About 4 months after the demolition, Vanessa's rebuilt garage was finished. Smaller, still nice, entirely on her property. There was a clean strip of grass between it and the boundary. My gravel lane ran beside it. One afternoon I was driving my old case tractor back toward the workshop when Vanessa stepped out to collect her mail. I slowed. She looked at the tractor, then at the road. For a moment neither of us said anything. Finally she asked, "Do you really use that workshop enough to justify all of this?" I shut off the tractor. All of what? The lawsuit, the demolition, everything. I thought about it. Then pointed behind me. "My father built that shop." She looked toward it. "He taught me how to weld in there." Vanessa said nothing. I stored my first excavator there. My daughter learned to drive a stick shift on this lane. I still work back there 3 or 4 days a week. I paused. But none of that is actually the reason. Then what is? It was already mine. She looked away. I started the tractor again. Before I drove off, she said, "I still think there could have been a compromise." There could have. She looked back at me. I pointed toward where her original foundation had crossed the lane. "Before you poured." That was the last time we ever discussed the garage. People who heard the story later usually focused on the demolition. They wanted to know what it felt like watching the machine tear into a building Vanessa had spent so much money on. I never had a satisfying answer. Because the machine wasn't the victory. The survey wasn't even the victory. The victory was being able to drive to my own workshop again without negotiating for access to land my family already owned. The bulldozer, or excavator if we're being accurate, was just the last tool required to get there. Dad used to tell me something whenever we were laying out a trench or setting forms. Measure before you make the mistake heavy. I didn't understand how good that advice was until I spent 6 months watching someone do the exact opposite. Vanessa thought concrete would make her claim permanent. It didn't. It only made the mistake heavier. and a lot more expensive to remove.